can I say there is no topic, I think, that is more complex because of its interaction with human nature, with relationships, with emotions than this area, and it is one that has to be dealt with effectively, but also compassionately, but also in a time frame that makes sure changes that we make actually deliver the outcomes that will improve. And my experience to date has said that there is no silver bullet, there is no change that is going to overnight make everything good for everyone, but at least we should be incrementally improving the system that we have. And can I say at the outset, one of my concerns with this legislation, and one of the reasons that I will be calling on both the government and the crossbench to give serious consideration to the amendments that are being moved by Senator Cash, is that the hearing for this was 1 day. 1 day. For a topic that, as I go back even through my time here in the House and in the Senate, there have been extended inquiries giving people the opportunity to not just have their views heard, but when draft legislation has come forward, the opportunity to delve into, will it be effective, and importantly, will there be unintended consequences? Will this lead to outcomes that actually take us backward, that make the situations for both parents and particularly for children even worse than they currently are? And so I am appalled, would not be too strong a word to use, to see that the committee was only given 1 day to engage with stakeholders, whether they be in the legal profession or others, around this legislation. I think that is a manifestly inadequate period of time to understand the likely efficacy and the potential for unintended consequences of this. And so I do encourage people to consider seriously the amendments put forward by Senator Cash, not treating them as a partisan issue, but as a genuine attempt to make sure that we keep moving forward and improving legislation as opposed to potentially going backwards. There are 2 areas that I wish to talk about, particularly Schedule 1, Part 2, which is around the presumption of equal shared parental responsibility, and Schedule 2, the enforcement of child-related orders. They are 2 issues that, through my time, and particularly as a member of the House of Representatives, have been raised with me frequently, but certainly Schedule 2, the enforcement of child-related orders, is something that people have continued to bring to my attention because of the great financial, emotional and other impacts on them when those child-related orders are not enforced and there is imbalances of power in the relationship, and it's a problematic area. Before I go into those in detail, though, I do wish to just give some overarching comments about how we as a society address this issue. I mentioned that I came in at the end of Kay Hull's work, and one of the things that led to that review back at that period was the concern about the disappearance of fathers from their children's lives in the aftermath of separation and divorce, and that drove a fair degree of interest. And interestingly, I go to President Obama, who's not someone I quote often. He comes from a different political view, perhaps to I, but quoting from a speech that he gave, and I quote, "Of all the rocks upon which we build our lives, we are reminded today that family is the most important, and we are called to recognise and honour how critical every father is to that foundation. They are the teachers and coaches, they are mentors and role models, they are examples of success and the men who constantly push us toward it. But if we are honest with ourselves, we'll all admit that too many fathers are also missing from too many lives and too many homes. They've abandoned their responsibilities, acting like boys instead of men, and the foundations of our families are weaker because of it." End quote. I think that's a realistic assessment of two things. One, that there is a role for both parents, but that both parents have to step up to that role and fulfil it. And one of the challenges that we see now is that with the degree of dysfunction in families, many young men have not had role models, and they have not seen in their own lives an example of what it means to be a father. And so one of the things we as a society should be saying is, how do we get alongside and help people to understand how to be a father, in fact, how to be a husband, about how do you communicate, how do you relate, have an emotional EQ as well as IQ and work ethic and all those other things. Now, this never comes cheap, but I think it's worth noting some of the research that highlights the mental health issues, which are doubled for divorced men and women, as opposed to those who remain married, the high and rising rate of suicide following marriage breakdown. Divorced women have taken their lives at a rate 4 times that for married women, while for men the rate is up to 3 times. Financially, AMP and NATSEM have highlighted the different impacts after a marriage comes apart. And they've said that whether it's income, equity, debt levels, long-term wealth potential, from a financial perspective, divorce is a loss-loss outcome. And why should government care? Well, even if we take apart all the fact we want people to flourish, we want well-being amongst our community, from a pure financial perspective, back in 2004, when I was first starting to get involved in this, some of the research that I looked at from the Department of Family and Community Services then indicated that for an average of 2 children per family, a marriage breakdown on average equaled $352 million each year in additional support by the taxpayer to families writ large who had suffered breakdown. I noticed in 2014, so 10 years later, News Corp had done a study, and their assessment was that in 2014 divorce was costing the economy $14 billion a year. So even from a crass financial perspective, there is a real incentive for government to work out how we can do better to support people who've come together in marriage to not go down the path of seeing that break apart and to find ways. And there are things that have been tried during that period when Mr Ruddock was the Attorney General. I was involved with him in seeking to shape not just the establishment that was coming out of various reviews. I think Professor Parkinson had a large hand in that, but the family relationship centres, which were designed initially to make the process of separating less confrontational, have less angst, to allow people to go their separate ways without that impact on them and their children. 3 of the first areas that eventually became part of their aim was to help couples about to be married to get information on pre-marriage education, to help families wanting to improve their relationships to get information about family relationship education and other services that can help strengthen relationships, and families having relationship difficulties to get information referred to other services to help prevent separation. The rest of it was then all post the separation part. Now, I'm not convinced that that was ever funded as well as it could or should have been, and yet we see examples in other governments, such as in New Zealand, where then Finance Minister Bill English set up, along with their tax working group and their capital markets working group, he set up a welfare working group in 2008 to actually do a detailed analysis of why the government was spending money, large amounts of money, to support people through various streams, whether it was mental health, education, the prison system, etc. And family breakdown was a key precursor to much of that expenditure, and they put in place some interventions. And what it says to me is that there are some ways where it is worth the government spending money up front to help people to appreciate the work of people like Gottman, who technically developed the cascade theory of marital dissolution, and he concluded that a lasting marriage results from a couple's ability to resolve the conflicts that are inevitable in any relationship. This comes down to two things. One, having the desire, the motivation to do it, so understanding why it's important, and secondly, having the tools to do it. And I would argue that it is worth the Commonwealth spending money on that. So very quickly, on to these two parts that are of concern. The presumption of equal shared parenting responsibility. I have looked through the long list of recommendations that came out of the Law Reform Commission's work into this, and they did note that there was a lack of understanding on behalf of many people, and the expectations of some going into this whole process of separating was that there should be an equal time, and that was causing problems. But what we see was that the original presumption was something that was supported by all sides of Australian politics because of that importance of having both parents in the life, and so in the life of a child. And so whilst I understand that relabelling, and there's various words that have been used, and I looked through some of the submissions that were given to the committee, where Professor Bruce Smythe, for example, stated that there is still a role for law to send out a radiating message that both parents matter and that children need both their parents to be involved in their lives after separation. And a number of witnesses who've highlighted that in attempting to implement the recommendation of the ALRC, rather than rebadge, these changes basically remove the presumption. And there is so much evidence here in Australia and overseas that says a child's best interest, all things being equal, obviously situations of violence, etc., but even going back to the laws that were put in place under the Howard government, things like domestic violence and potential for harm to the child were grounds to not have that equality. And so whilst I'm supportive of the fact that we should refine that, to refine expectations about equal responsibility, and it doesn't mean equal time necessarily, what this legislation does is overreach and goes too far. And there are many submissions from Professor Smythe, the Family Law Practitioners Association of West Australia, the Hunter Valley Law Practitioners Association, the Family Law Practitioners Association of Queensland, all highlighting in reasonably lengthy ways their concerns with the fact that this presumption is being removed, and that is something that I do not support. Schedule 2 about the enforcement of child-related orders. This is a complex area because of the interaction between Commonwealth and state jurisdictions, but it is something that we do need to act on. Schedule 2, I'm not convinced it will do it. Even the ACT Bar Association has given evidence again in the committee report highlighting some concerns around this. And their conclusion was that rather than simplifying it, they've actually made it a different complex mess. And so I'm conscious my time is running out here, but those two areas are of particular concern of mine, having dealt with them over a range of years, and I implore the Senate to consider the amendments from Senator Cash.